He was stinky.
Uh-huh.
That's right.
The good old days, I guess.
And Ron Harms. Remember Ron Harms?
He was afterwards, so.
All right, gentlemen, I'm showing we're a little past 9. Are we ready to tackle this?
Yes, sir.
All right. Good morning, all. This meeting is called to order. Mr. Troman, has anyone signed up for public comment?
Morning, Commissioners. No, we do not have anyone registered for public comment this morning.
All right. Thank you. Good morning, Ms. Miller.
Good morning, sir. I have just sent you the short form dissent list for today.
Perfect. Perfect. Let's see. We're going to tackle agenda item 3 first with you. And we do have a case to reconsider under agenda item 3.
Yes, sir, that is correct. Commission Appeals is requesting a letter of continuing jurisdiction in tax case number TD-20-077-0620. This case was voted on docket 38 on September 22nd, 2020. A decision was mailed the same day, September 22nd. There's no indication that any appeal has been filed, and the decision has not yet become final. On September 25th, 2020, the Texas 7th District Court of Appeals issued a decision in a separate case with issues similar to those in the case at hand. Commission Appeals is requesting to mail a letter of continuing jurisdiction so that the facts of case number TD-20-077-0620 may be considered in light of the court's decision on similar issues. Commissioner Alvarez?
I agree.
Commissioner Demerson?
Agree.
Mr. Chairman?
Agreed.
Thank you.
Thank you. Let's consider tax liability cases under agenda item 4. I believe we have 2 tax cases on docket 42.
Yes, sir, that is correct. The first case is TD-20-089-0720. Commissioner Demerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
The second case is TD-20-090-1119. Commissioner Demerson?
Agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
Thank you.
We have no fair housing cases under agenda item 5. Is that correct?
That's correct. No cases.
All right, let's move to agenda item 6. We have 1 wage claim case pulled for additional discussion on docket 42.
Yes, sir. That's case number 19-058-878-5. Commissioner Alvarez?
The decision is not supportable. The claimant is the only party to provide testimony in this case. She testified the employer's written policy provided 120 hours, vacation hours each year, and that she accrued but unused vacation was paid out at separation. The claimant has provided a written policy corroborating her testimony. Further, the claimant has denied the policy provided by the employer was ever shown to her or in place during her employment. The claimant had 88 hours of leave at separation. At her rate pay, the claimant is entitled to $1,658.80 in total gross unpaid wages. If my fellow commissioners do not feel there is sufficient evidence to award wages, this case should be reheard. The claimant offered to provide a witness who could testify that the handbook was changed after her separation. This witness was never called. Reverse the WCAT $1,658.80 wages owed.
The AT decision is supportable. The employer's paid vacation policy that was in effect during the final years of the claimant's employment provided a maximum of 80 hours of paid vacation per year. And it further provided that unused leave would not be paid out at that time, at the time of the work separation. The earnings statement from a few weeks before the claimant's work separation was consistent with the vacation policy that the employer submitted in response to the wage claim. Accordingly, we should affirm the AT decision. The claimant is not entitled to additional wages.
Agree here to allow the claimant to present a witness.
Thank you. We will rehear the case. And I did send you the wage claim short form dissent list just a moment ago.
I move we accept staff recommendations on the remaining wage claim cases on docket 42.
I second the motion except for those cases on which I am dissenting, as reflected on the wage claim short form dissent list for docket 42.
Concur with the chairman's motion, except for the cases on which I am dissenting, as reflected in the wage claim short form dissent list for docket 42.
Motion passes with the exceptions noted.
Thank you, sir.
Let's consider agenda item 7 and unemployment insurance cases on docket 42. Please proceed when you're ready.
Thank you.
Case number 2471904, Commissioner Alvarez.
The AT decision should be modified. The claimant's car broke down shortly before the hearing, which prevented him from being home in time to participate in the hearing. The claimant established good cause for his non-appearance. With regard to the job separation, the claimant left work with this employer when he was called to active duty with the Army National Guard. Such a separation was not voluntary. The claimant's reasons for leaving employment were urgent, compelling, and necessary. Modify the AT, claimant had good cause for his non-appearance, not disqualified, urgent, compelling, and necessary.
The AT decision should be affirmed. I do not dispute the good cause ruling. As to the job separation, although the claimant had a good personal reason for leaving work, per commission precedent, he quit without work-connected good cause. We should affirm the AT decision. The claimant had good cause for his non-appearance, voluntary leaving.
Modify the AT, claimant established good cause for AT1, no voluntary leaving, urgent and compelling.
Short form, Sherry.
Yes, sir, Commissioner Demerson.
Case number 2489274, Commissioner Dimerson.
The AT decision should be modified. I agree with the good cause ruling. As to the job separation, the available evidence supports a finding of misconduct, but I would also agree to a remand to cure the due process and issues involved with this case. Regarding the final incident, the claimant was discharged for her inappropriate behavior at work. Specifically, 3 first-hand witnesses testified that the claimant made profanity-laden comments about her manager and was slamming doors around the workplace. 2 of those witnesses also testified that the claimant had been warned previously about her attitude at work. The claimant also engaged in a screaming match with her boyfriend. This evidence, taken together, should hold more weight over the claimant's blanket and self-serving denials. Since the weight of the evidence supports that the claimant engaged in intentional wrongdoing, we should modify the AT decision. The claimant had good cause for a non-appearance, misconduct, no chargeback, adequate employer response, or remand in the alternative.
The decision should be affirmed. The claimant established good cause for her non-appearance because she did not receive the hearing notice. Regarding the job separation, the employer provided 3 witnesses to the final incident. However, each witness told a different story. One of the witnesses even changed their testimony during the hearing and ultimately admitted they didn't hear what the claimant said. Due to these inconsistencies and admitted perjury, the employer's witnesses are not credible. As such, the claimant's testimony that she did not throw a fit or call the manager names is more credible, and the employer has not shown misconduct. Affirm the AT, good cause for the claimant, no misconduct, chargeback.
Modify the AT, claimant established good cause for AT1, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2496537, Commissioner Alvarez.
The AT2 decision on timeliness should be reversed. The claimant did not file a timely petition to reopen because she did not receive the AT1 decision. Additionally, the appeal period was during the time period when the commission was experiencing delays and other difficulties due to the pandemic. On the good cause issue, the claimant did not appear for the AT1 hearing because he did not receive the notice for the hearing. He therefore had good cause for the non-appearance. Reverse the AT, timely petition to reopen, good cause for the non-appearance at AT1, and resubmit the case for merits testimony.
The AT decision should be affirmed. Regarding timeliness, the claimant filed his appeal well over a month late, and he did not allege having any mail issues or difficulties in reaching the agency. Instead, the claimant stated that he delayed filing his appeal because he was waiting for his wife to help him. Moreover, contrary to the claimant's testimony, UBS records indicate that the claimant was not regularly checking his inbox. Since there is no good cause exception to the timeliness rules, the claimant's petition should be dismissed for want of jurisdiction, and the underlying decision should remain in full force and effect. However, even if the claimant's appeal is deemed timely, he did not establish good cause for his non-appearance because his allegation of non-receipt is neither credible nor persuasive. As to the merits of this case, since the claimant was aware of the job duties when hired, and since he did not request a leave of absence or other accommodations prior to resigning, he quit without work connected to good cause. We should affirm the AT decision, untimely claimant appeal, voluntary leaving, no chargeback.
Reverse the AT, timely petition to reopen, claim and establish good cause for AT1, resubmit.
Thank you. We will resubmit the case.
Case number 2498442, Commissioner Alvarez.
I would modify the AT decision. I agree with the AT that the claimant established good cause for their non-appearance at the AT1 hearing because he was on a job interview during the hearing. On the separation, the claimant quit the job to check into a VA rehabilitation center for PTSD. He quit the job due to a medically verified illness. His separation should be therefore be non-disqualifying, and the employer's account protected from chargeback due to the MBI. In the alternative, I would agree to a rehearing to provide the claimant the opportunity to submit documentation that he entered a VA rehabilitation center to substantiate the medically verified illness.
I agree with Commissioner Alvarez with an MBI in this case.
Agreed.
Thank you. We have a unanimous decision.
Case number 2511474, Commissioner Alvarez.
The decision is not supportable as the wrong LEU has been named in this case. The evidence establishes the claimant will ask to work for an SR Care Home Solutions LLC from February 17, 2020 to March 20th, 2020, after she ceased working for the named employer and before filing her IC on March 27, 2020. As such, the claimant's IC lists the incorrect last work, and the claim is not valid. Since the claim is not valid, the voluntary leaving, reimbursement, and adequate response decisions are void. UIO and CS should be instructed to input a new IC claim with an effective date of March 22nd, 2020, naming the correct last work. Reverse the AT, claim not valid, void voluntary leaving, reimbursement, and adequate response decisions. Memo to UIO and CS to input a new IC naming the correct last work.
The AT decision should be modified. I agree that the claimant filed a valid claim. As to the job separation, the claimant quit a full-time job for another job that did not materialize. For a commission president, such a job separation is without good cause connected with the work. To therefore modify the AT decision, valid claim, voluntary leaving, reimbursing employer not bill, sever adequate response.
Modify the AT, valid claim, voluntary leaving, reimbursing employer not billed, sever adequate response, memo to UIO and CS to investigate whether the claimant is eligible for a PUA claim.
I agree with that, Chair.
Short form dissent?
Yes, sir. I have your short form dissent, Commissioner Alvarez, and a memo to UIO and CS to investigate PUA eligibility.
Case number 2550773, Commissioner Alvarez.
The recommendation is not supportable. The AT decision was mailed on July 1st, 2020. On July 2nd, 2020, the claimant submitted an address change via the internet. In accordance with longstanding commission precedent, a notice of change of address is a timely appeal from any pending determination or decision adverse to a party. As the claimant submitted an address change during the appeal period, he has filed a timely appeal. There is no requirement as to the substance of the address change or that the claimant failed to receive the TWC document as a result of the change. Timely claim an appeal and resubmit for merits.
The claimant filed his appeal about 6 weeks late. There's indication that the AT decision was mailed to an incorrect address and the claimant did not raise any allegation of non-receipt. In addition, the claimant's otherwise late appeal should not be deemed timely based on his attempted address change, since neither the removal of the last 4 zip code digits nor the inputting of an invalid address result in any actual address change. As such, we should dismiss the claimant's appeal as late and leave the underlying AT decision in full force and effect.
Late Commission appeal, AT decision remains in full force and effect.
Short form dissent.
Yes, sir, I have your short form dissent.
Case number 2555860, Commissioner Alvarez.
The AT decision should be affirmed. The employer filed a late protest to the notice of initial claim because the employer's representative was busy with a large number of UI claims. The notice of initial claim was timely, delivered to the employer's representative in the specified manner. The Commission has consistently held that the employer's reason for filing a late protest is not a reason for which the protest can be deemed timely. Affirm the AT late employer protest, no misconduct, bill the reimbursing employer.
The AT decision should be reversed. First, the entirety of the response period in this case occurred during the time the TWC was in technical difficulties receiving claims. In addition, the employer stated that a timely response was not feasible. The employer, a fellow governmental entity, was attempting to process a year's worth of claims in a month with a limited amount of staff. The employer did not sit idly by, and since the pandemic has resulted in the reimagining of normal processes and procedures, a similar approach ought to be applied to situations such as those reflected in the case before us. Thus, the employer's protest should be deemed timely. As to the merits of this case, the evidence shows that the claimant quit or not agreed to an MVI because the claimant did not provide medical documentation to the employer, nor did she state that a doctor advised her to quit. To the extent that the claimant had any complaints about her job, the claimant elected not to escalate her concerns, thereby depriving the employer of a reasonable opportunity to address them. The claimant did not take adequate steps to protect her job, and we should reverse the AT decision. Timely employer protest, voluntary leaving, or not bill, adequate employer response.
Affirm the AT, untimely employer protest, no voluntary leaving, bill reimbursing employer.
Short form dissent, Sharon?
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2558407, Commissioner Alvarez.
The decision is not supportable. I agree that the claimant filed a timely appeal. The claimant received a lump sum payment in accordance with the employer's severance plan. The plan had been in place prior to the claimant's separation. As the payment was due to the employer's pre-existing severance pay plan, it is not disqualifying under Section 207.049B of the Act. Modify the AT, timely appeal, severance, eligible, no overpayment.
The AT decision should be affirmed. I agree that the claimant filed a timely appeal. Regarding the severance pay issue, the claimant received 26 weeks of severance pay from the employer. The pay did not fall under any of the non-disqualifying circumstances listed in Section 207.049B of the Act. We should therefore affirm the AT decision, timely claimant appeal, severance pay disqualification from April 12, 2020 through September 26, 2020, overpayment of $1,563.
Modify the AT, timely claimant appeal, no severance disqualification, no overpayment.
Short form.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2559491, Commissioner Alvarez.
The decision is correct. The employer testified they received the notice within the appeal period, but did not timely respond due to a high volume of claims. The failure of the employer's third-party administrator to timely address the claim does not provide an exception to the timeliness rules. Affirm the AT, late employer appeal, bill reimbursing employer.
The appeal tribunal decision should be reversed. While the employer's appeal was submitted beyond the appeal deadline, the employer was experiencing an unprecedented flood of claims stemming from the pandemic. It was simply not possible for the employer to be timely. Given the totality of the circumstances, the employer's appeal should be deemed timely. As to the job separation, the claimant resigned to take a position with another organization. The employer had continuing work for the claimant, and his job was not in jeopardy. As such, the claimant initiated job separation was without good cause connected with the work. We should therefore reverse the AT decision, timely employer appeal, reimbursing employer not billed.
Affirm the AT, untimely employer appeal, bill reimbursing employer.
Short form.
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 2560530, Commissioner Alvarez.
The decision is not supportable. The claimant is a server who earned $2.13 per hour plus tips. Due to the pandemic, the claimant was laid off. The employer paid the claimant furlough pay of $4.23 per week for 3 weeks, for a total of $12.69. This amount is substantially below the claimant's weekly earnings. As the furlough pay does not approximate her actual earnings, she did not receive disqualifying severance pay. Reverse the AT, severance eligible, no overpayment.
The appeal tribunal decision should be reversed. The claimant received post-separation pay that appears to be less than her normal wages. Given the circumstances, the severance disqualification should be removed. We should therefore reverse the AT decision. No severance disqualification, no overpayment. Memo to UIO and CS regarding possible unreported earnings.
Reverse the AT, no severance disqualification, no overpayment.
Thank you. We have a unanimous decision and a memo to UIO and CS to investigate possible unreported earnings.
Case number 2563778, Commissioner Alvarez.
The decision is not supportable. I agree that the claimant did not have good cause for missing the first hearing. However, there was sufficient evidence available to the first AT to establish that the claimant should not be disqualified. The employer issued a memo to the employees informing them that they were reducing capacity due to the pandemic. The employer offered employees a program where they could take a leave of absence and receive pay for 36 hours a month. The claimant accepted the leave offer and was approved. As the claimant ceased working at the offer of the employer and due to economic conditions caused by the pandemic, the claimant should not be disqualified for benefits, from benefits. Modify the AT, no good cause, no voluntary leaving, no chargeback, disaster.
The appeal tribunal decision should be affirmed. Since the claimant did not review the hearing packet, she was not prevented from attending the hearing due to circumstances beyond her control and did not establish good cause for her non-appearance. As to the job separation, it does not appear that the claimant was notified she would be imminently discharged from her job or that she would be laid off from work. Accordingly, since the leave that the claimant took was voluntary, she initiated the separation and quit without work-connected good cause. We should therefore affirm the AT decision. The claimant did not have good cause for a non-appearance, voluntary leaving, no chargeback.
Affirm the AT, claimant did not establish good cause for AT1, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2566808, Commissioner Alvarez.
The decision is not supportable. The claimant ceased working when the employer shut down due to the pandemic. The parties clearly testified the claimant received her pay for the school year annualized over 12 months. The payments the claimant received during the summer were merely annualized payments for wages earned during the prior school year. Such payments are not reportable as earnings during the summer. The claimant does not have any earnings attributable to work performed during the summer. As the claimant ceased working prior to filing her IC, and all payments from the employer are attributable to work performed before the employer ceased operations, the claimant filed a valid claim. Reverse the AT, valid claim.
The AT decision is supportable. The claimant was on a regular pay status during the entire summer, including the week in which she filed her claim. She normally works and is paid during the summer, even when the school is normally in a summer break, and so the regular pay that the school gave her each week meant that she was not unemployed when she filed her claim or during any week thereafter. Even if she could have been considered partially unemployed, the school was giving her exceeded 125% of her weekly benefit amount. Accordingly, we should affirm the AT decision. The claimant filed an invalid initial claim.
Affirm the AT invalid claim.
Short form dissent.
Yes, sir, Commissioner Alvarez, I have your dissent.
Case number 2570522, Commissioner Alvarez.
The AT decision should be reversed. When she lost her job, the claimant tried to file an initial claim in Oklahoma in the week of 3/26/20. She was told to file in Arkansas, which she did, but was finally instructed there to file a Texas claim. The claimant made a good faith effort to file an initial claim when she became unemployed, and she established adequate cause under section 207.021A2 of the Act for her claim to be backdated. Reverse the AT, backdate the initial claim to 3/26/20.
I do not believe that the evidence supports the AT decision. Absent from the AT decision or the staff analysis so far is any explanation of why the claimant was not allowed to file her claim in the first state she tried, which was the state where she worked, or in the second state she tried, which was the state of her residence. The first state had instructed her to file in the state of her residence. She did so, and that the second state rejected her claim as well. Only after the second state suggested she file in Texas did she do so. In addition to that, it took the first two states quite some time to respond to the claimant's request for assistance regarding which state she should file in. The AT decision faults the claimant for confusion over which state to file her claim in, but the records show clearly that at least one of the other states shared that confusion. In addition, it seems doubtful that any non-UI professional would be in a position to know which state wages are reported to, if that state is not the state in which the work is performed or the state of the claimant's residence. In such cases, confusion over which state to file in would seem to be good cause for backdating the claim. Accordingly, we should reverse the AT decision. The claimant has shown good cause for backdating her claim to March 22nd, 2020, which was the Sunday preceding the date of her work separation.
Reverse the AT, backdate the initial claim to March 22nd, 2020.
Commissioner Alvarez, the date of the IC differs from your vote, I believe. Do you have any dissent or no?
I would agree to the 22nd.
Thank you very much.
Yes, ma'am.
Unanimous decision. Next case.
Case number 2570687, Commissioner Alvarez.
The AT decision is not supportable. The claimant was furloughed and was paid $250 by the employer as a disaster relief payment. Her employment relationship was not severed, and the payment therefore does not constitute severance pay as defined by section 207.049 of the Act. Additionally, the $250 disaster relief payment was well below the claimant's weekly earnings and unemployment benefits amount and did not qualify as disqualifying severance pay for that reason as well. Reverse the AT, no severance pay disqualification.
The appeal tribunal decision should be reversed. The claimant received a one-time payment that was classified as disaster pay relief and does not have the appearance of traditional severance pay. Of course, we should reverse the AT decision, no severance pay disqualification, no overpayment, a memo to UIO and CS regarding possible unreported earnings relating to the claimant receiving disaster pay relief.
Reverse the AT, no severance disqualification, no overpayment.
Thank you. We have a unanimous decision and a memo to UIO and CS to investigate possible unreported earnings.
Case number 2572366, Commissioner Alvarez.
The decision is not supportable. In her appeal, the claimant states that severance was paid in accordance with the employer handbook. The case should be reheard to enter a copy of the handbook into evidence and determine if the severance was paid as part of a pre-existing policy.
The appeal tribunal decision should be affirmed. The claimant stated that she was paid 21 days of wages in lieu of notice based on her time with the company. The pay did not fall under any of the non-disqualifying circumstances of 207.049B of the Act. We should therefore affirm the AT decision. The claimant received wages in lieu of notice from March 29th, 2020 through April 18th, 2020.
Reverse the AT, no wages in lieu of notice disqualification.
Commissioner Alvarez, I believe your vote was to rehear. At the moment, we do not have a majority vote.
I would agree with the chairman's, his decision on this case.
Thank you. No severance pay ineligibility.
Short form.
And the short form dissent, Commissioner Demerson.
Thank you.
Case number 2577780, Commissioner Alvarez.
The decision should be modified. The claimant cares for his 65-year-old father who has a compromised immune system due to HIV. The claimant stopped working due to the risk to his father. The claimant's reasons for leaving work were urgent, compelling, and necessary. Modify the AT, not disqualified, urgent, compelling, and necessary. Void chargeback ruling.
We should affirm the appeal tribunal decision. I agree that the claimant initiated the job separation when he notified the employer that he was not returning to work until the pandemic ended, and by filing his claim that same day. The claimant quit his job because of fear of COVID-19 and the status of one of his family members. However, he did not establish that the employer was failing to comply with safety guidelines, nor did he provide the employer an opportunity to remedy any of his concerns before quitting without notice. Under these circumstances, the claimant's quitting was without good cause connected with the work. We should affirm the AT decision, voluntary leaving, avoid chargeback.
Affirm the AT, voluntary leaving, void chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez, I have your dissent.
Case number 2578179, Commissioner Alvarez.
The decision should be reversed. The claimant was off of work in January and February with the employer's permission. The claimant's minor child had to have surgery, and then the claimant was on bereavement leave due to her father's murder. The employer has not denied that the claimant had permission to be off from work. When it was time for the claimant to return to work, there was no job to return to due to the pandemic. Reverse the AT, valid claim, no voluntary leaving, no chargeback, disaster.
Modify the appeal tribunal decision. I agree that the claimant filed a valid claim. As to the job separation, because the claimant stopped working due to her daughter's medical issues, the claimant should be qualified for benefits and the employer's account should be protected from charge under a medical separation analysis. Accordingly, we should modify the AT decision. The claimant filed a valid claim, no voluntary leaving, no chargeback, MVI of a minor child.
Modify the AT, valid claim, no voluntary leaving, no chargeback, MVI.
We have a unanimous decision. Claimant is qualified, no chargeback, valid claim, MVI.
Yes, I would agree with them.
Thank you. Next case.
Case number 2578514, Commissioner Alvarez.
The claimant should be given a hearing on the timeliness of her commission appeal. While dealing with serious medical problems, the claimant has been issued numerous determinations and decisions across her regular PUA and PEUC claims. These numerous inconsistent determinations and decisions could have misled the claimant into filing a late appeal. As such, the claimant should be given a hearing on the timeliness of her commission appeal.
We should dismiss the claimant's appeal as late. First, the claimant did not allege either delayed receipt or non-receipt of the AT decision. In addition, the claimant's appeal does not meet any of the exceptions in the timeliness rules. Thus, because the claimant's appeal is late, we do not have jurisdiction to consider the underlying merits. Accordingly, we should dismiss the claimant's appeal as late and leave the underlying AT decision in full force and effect.
Late commission appeal, the AT decision remains in full force and effect.
Short form dissent.
Yes, sir, Commissioner Alvarez, I have your dissent.
Case number 2580626, Commissioner Alvarez.
The decision should be modified. The claimant worked as a home health care attendant. The claimant's last assignment ended with her client when her client passed away. The claimant is over 65 and is at risk of developing severe illness if she contracts COVID-19. The claimant was offered several short assignments and an assignment that was in a facility where she would be exposed to multiple risks. The claimant did not accept new assignments due to the risk. The employer provided some PPE, including gloves and hand sanitizer, but did not provide masks. The claimant had good cause to turn down assignments due to the increased risk of developing COVID. Modify the AT, no voluntary leaving, no chargeback disaster, void adequate response.
We should modify the appeal tribunal decision. Because the claimant worked as a home health care worker, it is proper to apply the home health care precedent to this case. Here, the claimant initiated the job separation by rejecting assignments from the employer. Because the claimant rejected an assignment based on her personal preference to only work 4-hour shifts and not work on evenings or weekends, the claimant's quitting was without good cause connected with the work. As such, we should modify the AT decision, voluntary leaving, no chargeback, sever adequate response.
I concur with Commissioner Alvarez.
Chair, I'm going to short form dissent. In addition, based on the claimant's statements that she worked only 4-hour shifts and didn't work evenings or weekends, we should send a memo to UIO and CS to investigate whether the claimant was available for work as well.
Thank you. We have claimant qualified for business benefits, employer not charged, disaster, void adequate response. Commissioner Demerson, I have your short form dissent and a memo to UIO and CS to investigate availability for work.
Thank you.
Case number 2580773, Commissioner Demerson.
We should reverse the appeal tribunal decision. Prior to the claimant's initial claim, she failed to return to work for the fall 2019 school term despite having reasonable assurance. As such, the claimant initiated the job separation. Because there is no evidence in the record indicating that the claimant had good cause to quit, the employer's account should not be billed. Therefore, we should reverse the AT decision, reimburse an employer, not billed.
The decision should be affirmed. The claimant was a substitute teacher. She was laid off at the end of the semester when no further work was available. The employer testified that there was no work for the claimant until several months after the claimant's last day of work. Therefore, the claimant was laid off. Affirm the AT, bill, reimburse an employer.
Reverse the AT, reimburse an employer, not billed.
Commissioner Alvarez, do you have any dissent?
Yes, ma'am. Short form dissent.
I have your short form dissent, sir.
Yes, ma'am.
Case number 2581176, Commissioner Demerson.
We should modify the appeal tribunal decision. I agree that the claimant filed a valid claim but disagree with the job separation ruling. First, the job separation was initiated by the claimant, not the employer. Prior to filing her claim, the claimant voluntarily resigned while work was still available when she rejected the employer's letter of reasonable assurance. This notified the employer that the claimant no longer wanted the employment relationship to continue. Since the claimant quit, the analysis then shifts to whether she had good cause to do so. The claimant quit because she was not guaranteed a specific placement for the next school term. However, as a substitute teacher, this is the nature of the work. In addition, the claimant accepted the pay scale for substitute teachers when she began her employment. Thus, because the claimant failed to show good cause connected with the work for quitting, we should modify the AT decision. The claimant filed a valid appeal, voluntary leaving, reimbursing employer not billed, adequate employer response.
The decision should be affirmed. The claimant filed a valid claim regarding the job separation A few weeks before the end of the semester, the employer told the claimant that her position was going to be eliminated after the end of the semester. The claimant worked until the end of until the semester ended, and no work was available for the claimant during the summer. As such, the claimant was separated because her position was eliminated when the semester ended, and no further work was available at the time. Affirm the AT, valid claim, no misconduct, bill reimbursing employer.
Affirm the AT, valid claim, no misconduct, bill reimbursing employer.
Short form.
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 2581350, Commissioner Alvarez.
The decision should be reversed. The claimant recently returned from maternity leave. The claimant's infant was born prematurely and had a history of respiratory distress syndrome. The employer offered employee hotel accommodations so that they could quarantine away from their families, but the claimant was breastfeeding and could not quarantine away from her infant. The employer failed to provide N95 masks to the claimant and refused to allow her to use her own N95 mask. The claimant quit because her infant was at high risk of severe illness if he caught COVID. Reverse the AT, not disqualifying, urgent, compelling, and necessary. Bill reimbursing employer, void adequate response.
We should modify the appeal tribunal decision. The claimant's testimony establishes that she quit her job without advance notice due to child care issues. The employer provided several avenues of accommodation for employees to assist them during the pandemic, yet the claimant did not avail herself of any. Under these circumstances, the claimant's quitting was without good cause connected with work. Accordingly, we should modify the AT decision, voluntary leaving, reimbursing employer, not bill, sever the adequate response issue.
Modify the AT, voluntary leaving, reimbursing employer, not bill, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2581640, Commissioner Dimerson.
We should remand this case back to the appeal tribunal. In its initial appeal, the employer indicated that it would need a Spanish language interpreter for the appeal tribunal hearing. However, no interpreter was provided in waiting when the employer joined the hearing. While the company president stated she would proceed without an interpreter, it is difficult to know whether any content or context was lost because of the lack of an interpreter. Thus, the employer's apparent waiver to have an interpreter present should not control. Accordingly, because the agency failed to have an interpreter present for the hearing, we should remand this case to the appeal tribunal with an instruction that a Spanish-speaking interpreter be available.
The AT decision is affirmed, should be affirmed. The claimant was separated from employment with this employer when she was transferred at the employer's convenience to a different restaurant under the same ownership umbrella, but with different employer account numbers. Per long-standing commission president, the claimant was therefore involuntarily separated for non-disqualifying reasons, and the employer's account should be charged.
Remand.
Thank you. We will remand the case.
Case number
One moment, Shannon.
Sorry.
Commissioner Alvarez, did you want to dissent the remand?
Let me wait and see. I will short form this case.
Okay, we have a remand with Commissioner Alvarez's short form dissent.
Yes, ma'am.
Thank you.
Chair. Thank you, Ms. Miller.
Yes, sir.
All right. Case number 2583118, Commissioner Dimerson.
The AT decision is not supportable. The employer presented uncontradicted testimony about the reason for the claimant's termination, which involved the claimant maintaining an improper personal relationship with a subordinate employee. Under TWC precedent cases, an employer's secondhand testimony can justify disqualification if the claimant does not offer any evidence at the hearing to oppose the employer's evidence. The employer's response to the claim notice was adequate, since it gave a specific explanation for the claimant's termination. Accordingly, we should reverse the AT decision, misconduct, no chargeback, adequate employer response. In the alternative, if my fellow commissioners are not prepared to rule against the claimant at this point, we should hold a rehearing. The employer should have been allowed to enter its evidence of a cell phone message in which the subordinate employee admitted to the relationship. Although after acquired evidence is properly excluded if it relates to something other than the reason for the work separation, it is definitely admissible if it directly relates to and supports the specific reason for the termination, which it does in this case. The claimant would, of course, have the right to participate in any such rehearing and deny the authenticity of his former subordinate's cell phone message. Accordingly, I could support a rehearing in order to obtain the message and to allow the claimant and the subordinate to appear and deny its authenticity.
The AT decision should be affirmed. The claimant was discharged because of rumors and gossip in the workplace that he was involved in a relationship with a subordinate coworker. Both the claimant and the other employee denied a relationship. The employer's evidence of this relationship consisted almost exclusively of secondhand hearsay from unidentified third parties. The employer did not provide sufficient credible or persuasive evidence to establish that the claimant's misconduct. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson, I have your short form dissent. That is the last UI case pulled for additional discussion under agenda item 7. I earlier sent you the short form dissent list for unemployment insurance cases on docket 42.
Move we accept staff recommendations on the remaining UI cases on docket 42.
I second the motion except for those cases on which I am dissenting, as reflected on the UI short form dissent list for docket 42.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the UI short form dissent list for docket 42.
Motion passes with the exceptions noted.
Thank you, sir.
Thank you. This brings us to the end of agenda items 3 through 7. Let's pause for a few minutes to reset for the rest of the meeting. All right, we're back. On agenda item 8, staff does not have anything to present for this item. Agenda item 9, discussion, consideration, and possible action regarding publication for public comment of proposed amendments to 40 Tech Chapter 803 Skills Development Fund. This item is being postponed to a future meeting so we can have a full discussion of our proposed edits to the rules.
Chairman, have we confirmed on a date for that rules?
It's my understanding we have, but I don't know what that is. We were working that out with the general counsel's office.
Okay. Perfect. Thank you, sir.
Yes, sir. Let's move to agenda item 10, statewide initiatives, although I'm told staff does not have anything to present for this item. On item 11, discussion, consideration, and possible action regarding guidance on resource utilization and implementation of services and strategies to target disaster relief efforts and public health emergencies, including those funded with the Department of Labor's Disaster Dislocated Worker Grant. And I think we have a discussion paper on this item.
Yes, sir. And Travis Weaver is going to lay that out.
Thank you.
Thank you. Good morning, Mr. Chairman Daniel, Commissioners, Mr. Cerna. For the record, Travis Weaver, Workforce Development Division. On April 16, 2020, the Department of Labor awarded $12 million in disaster dislocated worker grant funds to expedite disaster relief services in Texas. And on September 29th, TWC received an additional $27,685,179 for a total of $39,685,179 to serve a minimum of 2,042 Texans. Of the 28 workforce development boards, 16 have been participating in this disaster dislocated worker grant to serve individuals and communities impacted by this pandemic. Disaster dislocated worker grants are supplemental resources that provide flexibility in responding and recovering from disasters, and DOL expects these grants to be aligned with existing state and local priorities, resources, and programs. Disaster dislocated worker grants provide disaster relief and humanitarian assistance employment, as well as career and training services and support services as appropriate to minimize the employment and economic impact of declared disasters and emergency situations in disaster declared areas. Participants served and original funding amounts have been adjusted forward to reflect the additional funding from DOL in the chart below. Today, staff seeks approval from the Commission on the use of the additional $27,685,179 for a total of $39,685,179 to serve a minimum of 2,042 Texans through the disaster dislocated worker grants with 16 boards. Commissioners, this concludes my comments. I'm happy to answer any questions.
Comments or questions?
Chairman, I have one question for Mr. Weaver. Mr. Weaver, can high school kids be eligible for this funding?
We are actually working with DOL on that question. We have provided that answer, and Commissioner, let me get back to you in your offices on that.
I'd appreciate that. Thank you.
Yeah, absolutely.
Other comments or questions?
I just like to say we're excited about this opportunity and the board's work in getting this out to Texans. Appreciate it.
Thank you, sir.
All right, do we have a motion?
Chairman, I move that we approve the use of the additional $27,685,179 for a total of $39,685,179 to serve a minimum of 2,042 Texans through the disaster dislocated worker grants with 16 boards as discussed.
Good. Second the motion.
Been moved and seconded. We're unanimous.
Thank you, sir.
Thank you. Ed, do we have anything else under item 11?
No, sir, we do not.
All right, let's move to item 12, discussion, consideration, possible action regarding approval of local workforce development board nominees.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Dimerson, and Mr. Cerna.
Morning.
For the record, Shunta Williams with the Workforce Development Division. And before you for consideration, we have workforce board nominees for Workforce Solutions, North Central Texas, Golden Crescent, Middle Rio Grande, Permian Basin, Rural Capital Area, and Texoma. This concludes my request, and I'm here to answer any questions you may have.
Comments or questions?
Chairman, I do have comments. Regarding the nominees for the Middle Rio Grande, I would like to start off by thanking both nominees for their interest in serving as board members. Both nominees represent entities that do not have any active employees. While this may be a worthwhile perspective within a board, this board already has similarly situated members to provide such a perspective. In general, it would be my preference to see private sector representatives actively engaged in supervision, hiring, firing, promoting, and other managing employees within the workforce area. This board is already well above the minimum board member size, so minimum board size is not a concern here. We should not at this time approve the nominees for the Middle Rio Grande.
Additional comments or questions?
Based on what I'm hearing, it's kind of out of the private sector individuals. And so I'd like to take a look at what Commissioner Alvarez has raised. It's coming forth from the board. And so I respect what they're putting forward. But I want to go ahead and take a look at this and then take action on it as fast as possible after a review. And so if it comes back up next week, then we'll get that going. But this is the first I've heard about those private sector individuals. again, respecting the board's submission of those names, is something that I respect. But based on the comments, let me look into that, especially from the private sector standpoint.
Is anybody in any danger of a compliance issue if we just delay consideration of this entire item to next week?
Sir,
No, sir, I don't believe that we are. Go ahead, Shanta.
I'm sorry. No, sir.
Commissioners, would you agree to delay consideration of this item for 1 week so that everyone can do their proper due diligence?
I would hear, Chairman.
Yeah, I agree based on your comment. Compliance in that regard. Thank you.
We'll push on this one. We'll pick this back up next week.
Okay.
Thank you, Chairman. And we did check with staff to make sure that they would not be, that this would not hurt them at a future board meeting. So thank you for that.
No, thank you. Let's see, that was item 12, was it not?
That's
Yes,
correct, sir.
Yeah, item 13, there's not a legislative report today. Ed, do we have a executive director's report today?
I don't have anything to report this morning, sir.
Is there any
Chairman.
other?
Chairman, I'm sorry, but could I go back on item 12? Could we approve the other board nominees with the exception of Middle Rio at this time?
Well, I asked if anybody was in any kind of jeopardy for compliance issues, and the answer was no.
I know for the Middle Rio Grandees, it was the only board that I checked to see if we were in compliance. I didn't check with the others.
Yeah, Ms. Williams confirmed that there was no issues if we just delayed the whole item.
Correct.
Okay.
It's probably more orderly that way, Commissioner.
Agree.
Okay. Any other order of business to come before the commission?
None here, Chairman.
Okay, I'm not. Do we have a motion to adjourn?
I move that we adjourn, Chairman.
Second the motion.
I could get behind that, so we're unanimous.
All right.
Thanks, guys. Y'all have a great week.
You too, sir.
I was going to say congratulations on your award.
Oh, well, thank you so much.
That was a big honor. So
These childcare issues have been particularly critical during the pandemic, and I know all three of us have put a lot of effort in that. I like to think I accepted that on behalf of all of us, but I guess they had to put a name in there. I really
not good. Congratulations, though.
Yes, congratulations, Chairman.
I just saw. Let me see a cuff link. I just saw a link on there.
It's a Rubik's Cube.
Ah, not bad. That's pretty cool.
Thank you.
Tommy liked that. So.
Oh, all right.
I'll see you guys.